Fight against impunity for the most serious international crimes and efficient prosecution of war crimes have been the key reason for the establishment of the International Criminal Tribunal for the former Yugoslavia. Since its establishment, it has been the subject of frequent criticism by the expert community. With its mandate completed, some important questions remained unresolved. The controversies revolve, by and large, around the efforts made by the states of the former Yugoslavia to cooperate with the ICTY efficiently. And while the efforts of some countries have been assessed as sufficient, the much greater effort of Serbia have not been adequately recognized. Serbia's record in this regard has been exemplary, both in terms of compliance with its obligation to cooperate with the ICTY and the result achieved within its national judicial system. And the compliance has been efficient and non-selective. The judgment rendered before Serbian courts are eloquent proof of Serbia's readiness to punish the perpetrators of the most serious crime committed in violation of international humanitarian law, irrespective of their nationality. Serbia has aligned its legislation with relevant standards, facilitating cooperation with the ICTY without exception and regard of all acts that the Security Council recognized in the ICTY statute as serious international crimes. Its commitment to fighting impunity has been reflected also by the number and the rank of the accused persons handed over the tribunal. Out of 46 persons whose extradition was requested by a tribunal, Serbia extradited 45. One person committed suicide before he could have been extradited. Some of them were in very high position, some of them high-ranking officers of Serbia's military, some of them high officials in its executive. A convincing illustration of my country's non-selective cooperation hardly matched by any other state. Serbia enabled the ICTY prosecutor free access to evidence, documents, archives, and witnesses. 2,183 requests for assistance have been submitted by the Office of the ICTY prosecutor and the Office of the prosecutor of the residual mechanism. All of them have been complied with. Serbia allowed 759 witnesses to testify freely, relinquishing the right not on account of state, military, or official secrets. 1,341 requests have been submitted by various defense teams. All of them have been complied with. Mr. President, in the ICTY final report, it is said that Serbia is not cooperating with the tribunal as it has failed to secure the arrest and transfer two persons in the case Jojic and Radeta. Characterized as the lack of political will for cooperation with the ICTY, the contention is erroneous and therefore unacceptable. It has been clarified several times by Serbian representatives. The competent, independent Serbian court has rejected the request under relevant law, aligned with the ICTY statute. Under the provision of the law and the statute, Jojic and Radeta committed no criminal offense. The following data, however, are much more illustrative of the deliverance of justice by ICTY. 161 persons have been indicted, 109 Serbs, 33 Croats, 10 Bosniaks, 7 Albanians, and 2 Macedonians. Proceedings against 156 persons have been finalized. Of the total number of sentenced persons, 70% are Serbs, 19% Croats, 6% Bosniaks, and only 2% are Albanians. These numbers speak tellingly about the selective justice of the tribunal, especially in the context of its mandate to establish the truth about the armed conflict in the former Yugoslavia and bring about reconciliation. In UNHCR report, it is said that 333,000 refugee Serbs from Croatia and 266,000 from Bosnia and Herzegovina ended up in Serbia in the wake of the armed conflicts, and 287,000 internally displaced persons from Kosovo and Metohija after the bombing of the Federal Republic of Yugoslavia in 1999. These numbers, Mr. President, make it difficult to us to understand why such a small number of persons have been found responsible for killing or expulsion of hundreds of thousands of Serbs. Is it the Serbian victims count for less? Only the Serbs have been passed life sentences in 5 cases before the tribunal. Such selective prosecution is a legitimate cause of legal concern and in some legal system provide the base for the pursuit of selective prosecution claims. In any case, it remains an issue for consideration of ICTY records in the future. The initiative of my country, Mr. President, related to the enforcement of sentences in the country of origin of the sentenced persons is another matter to which I want to draw the attention of the Council. We believe that it is hard to achieve the purpose of punishment and resocialization in case when sentenced persons serve their sentence in faraway countries. They are not enabled to communicate in the maternal language in those countries and have no possibility to receive family visits or maintain contacts with their relatives. Also, some of them are kept in inadequate conditions and provided inadequate health care. In launching the initiative, Serbia is committed to providing guarantees that in case of sentence enforcement transfers, all security measures will be taken and that it is ready to accept international monitoring. Serbia will continue to try war crimes, and it expects that other countries will do so too. Improving its national judicial system along the guidelines defined, among others, by National Strategy for Prosecution of War Crimes, adopted in 2016, continues to be one of Serbia's priority. To that end, the monitoring mechanism directed by the Minister of Justice and the war crime prosecutor have been established to monitor the implementation of the strategy. It is hoped that it will contribute to the effective prosecution of all those responsible for war crimes. Mr. President, the tribunal is receding into history, but its legacy is here to stay. The question, however, continues to linger as to whether it has accomplished its purpose. From our perspective, the statistical account of decisions strengthens our impression that it has been selective justice. The ethnic disparity of accused person, ICTY judgments and sentences, as well as the violation of the right of trial within reasonable time and the lack of respect for procedural guarantees will also be the legacy of the tribunal. In the eyes of Serbia and of many other countries that believes the law is a replaceable vehicle to ensure respect for and protection of basic human rights, the 13-year case of Vojislav Šešelj, who surrendered voluntarily, which ended in a first instance acquittal, is surely a stain of the proceeding of the tribunal. Mr. President, over more than 2 decades, the tribunal failed to note 2 important and relevant facts. First, during the celebration of the first anniversary of Croatia's independence in 1992, Franjo Tuđman, that the President of Croatia said in front of more than 100,000 people that the war could have been avoided, but that he did not want it. And second, in 1992, Alija Izetbegović, then the President of Bosnia and Herzegovina, withdrew his signature from Kutiljerov plan, signed by all 3 sides in Bosnia and Herzegovina. The plan could save peace and prevented the victims of civil war. In disagreement of this and other facts, and motivated by extra legal consideration, the tribunal, which we all believe was established, render justice impartially, has often come short of making a contribution to regional reconciliation and achieving fairness and equality, the fundamental principles of each and every legal order. In concluding my statement, I express the greatest respect for all the victims in the armed conflict in the former Yugoslavia, irrespective of nationality, religion, or any other affiliation. The need to work jointly on mutual understanding, regional cooperation, and reconciliation is indispensable. After all, for peace and stability in the region, it is necessary that effort be invested by all its countries and active, open, and constructive dialogue and cooperation be engaged in to bring about a better future, economic development, and normalization of relations.